Hi, I'm Angela Princeville, and I have Shirin Abdi here, who is our articling student, and Anissa Datu, who is a family lawyer with our firm. And today we want to talk about a subject that we get to litigate and negotiate often, and that's the matrimonial home. Under the Act, the matrimonial home has a very special place and it's treated differently from other properties in terms of how it's disposed of, rules around possession. But today we want to talk specifically about disposing of the matrimonial home and what to do with it, or how to dispose of it in the event of a separation. So I will have Anissa speaking about keeping the matrimonial home, and I'll have Shirin talking about why it should be sold and the proceeds divided between the parties. I just want to add that this is just a legal argument. Both of them work on files and represent different positions. It all depends on the facts of the case, but today they're both going to be speaking strictly on their separate positions, and that's, again, it's just their individual views for today, and it does not reflect on how they run their practice. So I would have Anissa go first. So you've come to me and you're a client. Why do you think that this matrimonial home should not be sold?
I have several reasons why I want to keep that home, why I want to love it, why it's full of memories. It's something that I, as a client, as an individual, as a parent even, cannot give up. First and foremost, like I mentioned, memories. The matrimonial home is full of memories, so many of them from your kids growing up to maybe even your grandparents living in the house, family members coming in, maybe a death, maybe a birth, maybe a wedding. So many different things that the matrimonial home has just encompassed over the years, and you just don't want to give that up. Personally, for me, that applies with respect to my own family, and it's also the fact that growing up, I was in my matrimonial home for as long as I can remember. I had wonderful neighbors. I had a wonderful neighborhood. I was able to leave as a child. I was able to leave my bike outside, not worry about it until the next morning. You can't do that with a lot of the newer areas, or with a lot of the areas you don't know about. And especially when you're separating from a matrimonial home, a lot of times that's a 2-income household that's now becoming a 1-income household. Given the range of income or the amount of disposable funds, or what an individual can afford, you're not living in the same area that the matrimonial home was in. You're going into a newer area, maybe an area that's not as safe, that's not as developed, or it could be an area where you don't have that trust, you don't have that community watch program.
Okay, so I'm going to stop you there for a minute, and I think, because I'm sure Shireen has a lot to say about this, so I'll just take these points one at a time. So we'll start with the last part, the income.
Yes.
What do you have to say about the 2 income to 1 income?
So to your point about the income, if you're maintaining that home by yourself with that one single household income, that income would have been the exact same income that would have maintained that family dwelling when the parties were together. Now, in terms of separation, if that party has to pay, if there's a support payer and a support recipient, in the majority of the time, they're not on an equal footing, and both of them can't afford to maintain that same property based on the same amount of income. As to the point of keeping the home based on the memories, in consideration of the courts, they don't factor that into account. So they want to be able to have both parties maximize the value of that home, and with holding the property with one spouse or and maintain that home, both parties should be able to maximize the equity in that home and the value of that home. And if one party refuses to sell, the court will not consider emotional attachments and ties. Although they may seem important, they're not in the main consideration. They look at the courts will consider the value that property brings to each spouse.
Now, I was wondering, like, in terms of memories, if there's a separation, aren't there now bad memories in that home? Is that how valuable what value should we place on these memories? Because a lot of times the home the relationship degenerated over time. I'm not sure what do you have to say about that?
With regards to the memories, sometimes it's not my own, sometimes it's not the parents or the client that comes to you. A lot of times I'm seeing it's memories that the parent or the individual wants to keep for the children. The kids have grown up in that home. They've had the benefit of like I said, witnessing milestones in that home, having their friends, it's their neighborhood, it's their school, it's everything they know, and it's everything that has kind of framed them and to be who they are. And like I said, that you can ride your bike, you have your friend down the street. Keeping the memories in the home is a big benefit for the children in their best interest, not to displace them, not to cause them that trauma, or because like I said, you don't know where you're going. It might not be as good quality, it might be better. Who knows?
Yes.
Who knows?
So now on the note of the children, because that's a big thread that we hear about the children, and I mean, having children myself, I can relate to that. So Shireen, what do you think about the children and these memories and wanting to remain in their neighborhoods?
Well, I think I understand why they would have that position. It's just in the actuality of it, having those parties, those spouses who are now separated, being able to have the money from the proceeds of sale is fundamental. And each party can get a new home, have a new life. And while a lot of people think that it's normal or typical for the children to reside in the matrimonial home, it's just not feasible, especially when one spouse is not being able to exercise that the possession of that home and the value of that property. And it's typically argued that it's even in the best interest of children who are of university aged. It's just not reasonable.
Anissa is arguing the best interest of the children. Do you think it's just about the values or the dollars and cents of it again?
I don't think it's just about the value, but I think you have to consider that the party who wants to maintain that home and live in that home has to incur significant amount of debt for the most part. And that wouldn't be in the best interest of the children, that those financial means can go towards the children as opposed to maintaining a home. In addition to the fact that if one party is occupying the matrimonial home, the other party's living arrangement may not be as substantial as the matrimonial home, and again, not in the best interest of the children. In addition, you've noted that the matrimonial home can have significant memories and emotional ties to the parties. However, for the children, it might be best. It also can have negative memories and impacts on the children, so maybe a fresh perspective, fresh home might even be in the best interest of the children.
Okay, I like that. And so how do you sort of deal with this situation where one party is in the home, they're tying down significant equity? Because we do know that if a party could buy out the other's interest, then it's usually a non-issue. So this argument usually comes up where one person is trying to stall because they legitimately need more time to get the funds together to buy out the other person's interest. And we find in a lot of cases that other party's living arrangement is not ideal. How do you tie this in with the Divorce Act, for example, where there's a requirement for maximum contact with both parents, and one parent is maybe living with the grandparents in just one room while the other is living in this huge matrimonial home with the children? Do you think that's in the best interest of the children still?
I do. Not in all circumstances, and I want to make that very clear. It's not a cookie cutter situation. Okay. But for a lot of my clients that are in this situation, I understand that sometimes, one parent leaves that home, goes and lives in a rented apartment, is couch crashing, lives with his parents or her parents, whatever it is. But for the kids, that's already trauma to them enough. The fact that their parents split up, they had that family unit, they had that maybe perhaps a nuclear family, and now it's not like that anymore. Yeah. They're now residing with one parent that they kind of see as the parent that's doing a lot for them, and things are going to change regardless. By keeping the home, what we're trying to achieve is not to let the kids experience more than they have to. Not to let them have to change their schools, change their friends. Maybe they can't go to their extracurricular activities anymore. Maybe they have to move complete different cities because of the fact that finances could be an issue. I understand with regards to the Divorce Act with the maximum contact principle, sure, the parent that's not the custodial parent, or not the parent residing in the home at the moment, access isn't going to be perfect. Truthfully speaking, it's never perfect, but the parents, it's really on the parents to make sure it works, because what their primary objective should be is not themselves, it should be the kids. With the parent who has left the house and perhaps is living with their parents, and it's not a facility where they can entertain the kids for an access visit, you know, maybe the parents need to maybe compromise, maybe do access visits in the house, maybe do access visits in a park, maybe try creative ways. Family law is all about, a lot of it is compromise and a lot of it is being creative, and as lawyers, that's our job, to be creative, and the courts really count on us to use our creative minds for that, to protect the best interests of the children in this case, because especially for kids who understand what happened. And you know, my friend did say that that they've seen those negative memories. They you know, they have that. They also have a lot of positivity in that house, despite the fact that they've seen the negativity. Doesn't mean that they should just get up and move. They can come to terms with it. It also helps them grow into mature adults. But the fact that, I actually find it very hard, because I had a case very dear to me where one parent moved out, and the fact that the kids had to sell, the other parent had to sell the home. The kids were completely displaced, and lost what they felt was everything. And for kids these days, changing schools, especially mid-year, and starting somewhere else is not fun. And it's not what they want to do at all. They actually resented the parent that moved out for that. They resented that parent for that, and it did not create a healthy access. It did not create it did not foster a relationship between them. So how is that in the best interest of the children? And at the same time, it's not that, it's they can still exercise the maximum contact principle, like you said. They can still have as much access as they want to have. They just need to be creative about it.
Okay, Shun, do you have anything to add to that, or your position still remains?
My position still remains, but I just want to add, okay, in a scenario where, say, the property of the value is increasing, the property markets are booming, would you say if just because of the best interest of the children, they shouldn't sell when they can get the most amount of maximized profits for that value, for that property, and then in which they would be able to both mutually afford a new home, each spouse? And again, to your point about being creative about access, now what about the winter? What about other aspects like that? It's each party still should reside in a suitable living arrangement for the children.
Now, and just one more thing I'd like you to touch on that, and I think Shireen had mentioned that earlier, about the effect of debt. Because usually, even the spouse residing in the home recognizes that at some point they need to buy out the other person's interest. And so eventually, let's say if we're in a scenario where that property has been bought out and it's in the other person's name, how do you deal with the debt? Now they have this significant debt to do, maybe they have to work longer, and this is money that could also, maybe they have to deprive the kids of things. In light of that, is it still advisable to keep the home? How much value should we place on stability of this, of not moving the kids? Because staying stability, I do agree, it means a lot to keep the children, but in the home, would you still put such a premium on that?
In certain circumstances, I would. You know, these parents have to be practical. If they know if they're living in a $2 million home,
okay,
and the spouse that moved out was the primary caregiver, and they know that they are going to have to deprive their kids of a lot of the luxuries, that's not the best interest of the children.
Okay.
I'm talking about the parents who know they can make it work, or you know, maybe they have to pick up a couple extra shifts, but things are never going to be the same. You can't just keep the kids the same, but you want to make sure that they're affected as little as possible. Okay. And kids need to understand that, you know, mom and dad aren't together anymore. There has been a separation and things are going to be different, and that's fine. But it doesn't mean that they should be giving up on everything. They can definitely come to terms with a lot of it. With regards to the debt, yeah, you just have to be practical. It's not, maybe, you know, like I said, be creative. Maybe that parent who stays in the home, maybe they can barely afford to buy out the other spouse's equity, or they can find different resources to help them to do so. Maybe they can borrow, maybe they can get a loan or something. Maybe then they can just rent out the basement. And then they're getting a little bit of income from that to help them afford the mortgage on the home.
Okay. So now, is there anything else that you want to add on this subject?
There's a lot of points that Shereen and I probably didn't touch base on that affect everyone. It's a case by case basis. We basically touched base on the bare essentials. Personally, growing up, for me, when I used to think about it, if my parents were ever going to split up, as a child, I never wanted to leave that home. So I really sympathize when it comes to my clients who come to me and say, you know, I want to do this for the kids. But at the same time, I also knew, depending on which parent moved out, my life would not be the same. So it's a lot of it is being practical, and part of our job as lawyers is really to help our clients understand that. So, you know, whether you love it or list it, it really depends. It's not a black and white situation.
I like that, Anissa. Love it or list it. So yes, if you had a judge looking at this and you know, having both lawyers make this argument, I think what they would try to find is that midpoint. You know, it's balancing the equities in the case, and of course it's never perfect, but they would try. They would look at the kids. Are you trying to move them midterm versus, you know, end of the school year? How old are these children? If they're younger, maybe a move they're not as established in the neighborhood per se, or you know, the equity in the home is there. Is it, how important is it for the other partner to get it at this time? Now, obviously, in a joint home, they do have a legal right to partition and sale of the home, but a judge would look at the timing, because they can hold off this sale until a trial, or do they order it now, dependent. So it's always, of course, best to talk to these lawyers, and I want to, you know, say thank you to both of them. They've made very strong arguments as always, and if, you know, it's either love it or list it, as Anissa said. I like that. Thanks.
Thank you.